which showed the balance at the bottom and a stamp paid in full. No, the court needs to see that zero at the bottom. And for whatever reason they wouldn't understand that. Now it's your duties as the executor. Gain possession, determine whether to liquidate each asset, engage tax professionals, get things lined up early so you can get them what they need for final tax returns, if there's any estate tax return that's potentially needed, any income taxes related to the estate. Please, no questions on that to me. I'll direct them over to Jerry because he's better with the accounting than I am. I joke and I tell my clients there's a reason I switched from marketing to marketing from accounting as an undergrad when I knew I was going to law school. I get those tax professionals involved early. All right, there's the mailed notice to creditors. This is part of the process too. If there is a known creditor and you haven't paid the bill yet, you're required to mail a notice, hey, the person died. Now, if you're just gonna pay the bill, you don't need that. But to Jerry's point from yesterday, you might be able to negotiate that down quite a bit, but you do have to mail the notice to them as a creditor. There's the published notice to creditors that has to go up for a period of time just to let everybody know. Now, I mentioned it's 3 months or 90 days in the statutes. What do you guys have for your time period that it has to be published?
120 days.
120 days?
90 days.
90 days? Okay. 6 months? Okay. So you also have to mail notice to the beneficiaries. Now, actually, I'm going to tell us just another quick story that was taught to me in a CLE. There was an accountant who died suddenly of a heart attack. His wife inherited everything as the spouse, and so she got that accounting practice ready for sale. And so she's boxing up his personal stuff, and a guy walks through the front door. It's like, is Jimmy here? No, Jimmy died. Oh, he owes me $50,000. I just come once a year and collect the money. And he had the proof, he had the contract, he had the list of payments. That notice to creditors had expired like 3 weeks earlier. He was out of luck.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
That was it. So that notice to creditors makes sense. Now, I occasionally have clients with very little or under the $20,000 mark. We'll still do the full probate proceeding to put that notice to creditors in the paper. In Jerry's words, if they're paranoid enough that they don't want to make sure that something doesn't pop up down the road, just to make sure that the notice to creditors has all of the official proceedings around it. I once filed it with, I think it was Mecklenburg, the Charlotte area, with zeros. There was nothing in probate, but we filed the full thing, and they called me up and said, why are you doing this? Notice to creditors. Oh, okay. And it made sense, but you have to do that formal process to get that notice to creditors. Just some other practical things. Cancel credit cards and automatic payments. And it's also not a bad idea. There are the 3 credit reporting agencies. Just go ahead and fax in a death certificate, because one of the scams that is out there is people taking out credit for someone who's recently died. And then suddenly the estate can get inundated with all of these unpaid credit card bills for the person, and it was all taken out after the person died. Well, you can prove that, but you have to take the time and the effort to prove it. It's easier to just go ahead and get those credit reporting credit agencies to realize the person's deceased. Now we're getting to the inventory. Any questions before that, before I get to the actual inventory? Yeah.
If there's a trust and it's basically pristine, and there's a will that's been changed and ink, does that automatically initiate probate?
I'm sorry, the will,
Or the will can changed by the client
Oh,
after before they die?
you mean they wrote on their original will?
Right.
Okay.
But the trust.
If there's nothing that's in probate, then the will has nothing to cover. Like you said, pristine. If there's assets that go into probate and they've got this will, you're gonna have to check your individual state to see if those markups voided the will. Yeah, David?
Yes, I just had something similar with the deceased had written on the will, and it took 8 to 10 months in this county for the judge to say, okay, the writing's valid, it tied everything up. But so do not write on anything.
Oh, yeah. Another story, this planning one, I had clients, didn't like any of their kids, had one special needs grandson that was living with them, set up all of the protections that we possibly could. So they had a revocable trust. There was an irrevocable special needs trust so that if there were other people who wanted to gift money to them to support them, it was in that special needs trust. Set up an IRA trust so that it could also protect him if there were any tax deferred assets and still get it spread out over, I think at that time, lifetime.
so good.
And then they needed to make one change. Okay, it's gonna cost like X number of dollars. We'll get back to you.
Uh-oh.
Didn't get back to me. About a year later, the daughter calls. Yeah, mom died. Dad is now incompetent. We're gonna have to talk about facilities and whatnot. And here's the will that they did. Did you do this? Because I talked with another attorney and it's like, that would be malpractice. I didn't do this. They had taken some language off a website, revoked everything we did. And now the only plan they had was that one thing within the confines of the will, and everything else went to the kids. So, yeah, don't write on your documents, yell at your clients if they come in and they've got handwritten stuff on their originals. Do whatever you can to stop them from doing that. All right, so, any other questions? Yes?
Real quick, speaking back to the credit cards, just because I know I've had lots of clients do this. We'll get the family together for the funeral. Is it okay if I use Dad's credit card to buy the tickets? No. Dead people cannot charge on credit cards.
Yeah.
And it is a very common
Yeah.
misconception that the kids or the personal representative makes the assumption on.
Yeah. Yeah. Because everything happens so quickly,
Yeah.
if they ask, I tell them, no, don't use those credit cards. Well, what do? We don't have access to anything.
Use your own.
Use one of your own credit
You'll
cards.
get paid back.
Save the receipts. Save all the receipts. Always save the receipts.
Right.
Once the estate account is established, then we can run it through that. Or, again, if there's a revocable trust, that can be done with a lot less formality than what we have to account for in probate. All right, any other questions before the inventory? All right, so the inventory, this is the baseline. Now that you've gotten your permission papers from the court, you can start collecting all these assets, get everything lined up. Now, on the inventory, you're putting in all of those exact numbers. Now, there's the section 1 that I talked about. It's totally in probate. That's the stuff that ends up on the inventory. All those section 2 stuff where you had to provide proof that it wasn't in probate, that was the application. We're past that now. This is just what's in probate, down to the penny. And so you put all of the information in, then you submit notices to the beneficiaries and you're signing off that you submitted notice to the beneficiaries and you're filing that. You submit an affidavit that you did notify the creditors if there were any. And then eventually the published notice to creditors paperwork goes in. Usually I'm just sending that in with that final piece of paperwork just because it's not necessary until that point anyway, because they just want to see it before you close out the estate. And just might as well mention it now so I don't forget. One other thing, apparently many years ago, the funeral lobby, they had some really good lobbyists because no estate gets closed without a paid in full funeral bill being submitted. So, yeah, they get paid. All right, so in looking at all of this stuff, one of the, just a practice tip, if it's not a ton of money that's in the estate, but it's over whatever that amount is, and you have to set up the estate account, because the next round of paperwork is going to have an awful lot of entries for whatever came in or went out of the estate, don't have interest-bearing checking account for the estate account.
Right.
If you're going to get 2 or 3 cents each month.
Right.
There was a financial advisor who was so eager to get, you know what, I'm going to tell the whole story, might as well, because this was part of probate. And it's also a story about not funding the trust the right way. I had clients, a couple, weren't married. They did a joint trust, and they had a whole bunch of bank accounts. They had most of their money in bank accounts. But this was back when FDIC limit was $100,000.
Right.
So they had somewhere in the neighborhood of like $1.6 million, anywhere between $50,000 and $75,000 spread out among all of these bank accounts. We'll get to funding, we'll get to funding, we'll get to funding it. No, don't worry, we'll get to funding it. Look, one of them was 14 years older than the other and not in great health, but it was all these accounts were joint with the right of survivorship. Driving home from church one night, younger guy's at the wheel, falls asleep, 18-wheeler, kills both of them. So what happens now? Half is in each of their estate. And so all of those accounts end up in there. I get a call from their church, hey, we know what happened, we had access to the house, we saw some papers with your name, did you do their estate plan? Yes, I did. Okay, well they passed on, we can get you the, I think we can get you the information for the funeral home to get the death certificates and whatnot. It's like, well, one of their nephews is the trustee and the executor. We'll get in touch with them, okay. They never got in touch with the nephew.
Ooh.
I'm on the phone, yeah, I'm very sorry for your loss. I lost. What are you talking about?
Oh, no.
It was, the nephew was a very specialized surgeon, so he couldn't just get up and leave. He had several weeks before he could actually go down. He's like, I'll pay you, go to the house and get the important stuff. Just whatever looks important. They were hoarders. We had so much stuff to wade through.
Oh, gosh.
We had to pack up so many records that we could find. And part of whatever was going on with them, they would typically only pay with $20 bills. And so whatever change just went on the kitchen table.
Oh, no.
I had to get one of their suitcases, shove all the money, including the change, into the suitcase, and I had to fill out one of those forms at the bank attesting that it wasn't drug money. Look, with all the pennies, nickels, and dimes in there, they were pretty sure it wasn't that, but yeah, it was a mess that we had to handle because of that. Now, this was the one where the financial advisor wanted all of the accounts. I'll set up the estate account. And the nephew's like, well, yeah, this is my financial advisor. I trust them. don't make it an interest-bearing account. Please, whatever you do, don't make it an interest-bearing account. Yep, he made it an interest-bearing account with his financial firm, and the rates were so low. It was 3 or 4 cents in interest every month for about a year and a half. And so each one was an entry on the form. Each one had to have the statement backing up that interest and highlighted, here's where the interest came from, as proof to the court, this is where the money came from. Because remember, it's got to get balanced down to the penny. The proof that's also needed for any of these expenses that happen, it was an issue. Nowadays, the banks are sending out the statements with copies of the canceled checks. Before, it was the actual canceled check. A friend of mine was doing an estate, executor didn't have the copy of the canceled check, clerk rejected it. It took like another 6 weeks to get a copy of the canceled check, resubmit everything. But there was a $5 charge with the bank that mandatorily had to come out of the estate account. So they had to reopen the estate account. The attorney put $5 in to get that check, and then the paperwork kind of had to be adjusted to all of this, because again, balanced down to the penny. You can kind of see why I hate doing this probate work, but that's exactly what happened. Okay, is this... Right,
Just frozen.
Vern? It's not advancing.
Looks like the software's frozen.
What's that?
So, not probate, this was a trust, but it was a close friend of mine who had no beneficiaries. And reluctantly, I said I would be his trustee.
Mm-hmm.
I was on a conference business trip and died. And fortunately, we had prepaid the funeral together. I had everything set up. So even while I was gone, everything got done. So me and my team went to his house to clean it out. Always look everywhere. I had a jacket I was going to give to a helper, and out of it fell rolls of $100 bills. All in
Okay.
all, I found $50,000 in sock drawers, clothes, every place you can imagine in his house.
Pages of the books in the bookcase.
Just,
Empty liquor bottles with money in them.
I mean, you
Somebody
have to
told her
check-
this was gonna happen. I'm not sure who that was.
Yeah.
Somebody told her this was gonna happen.
All right, well, we're gonna keep going, even if it's not up there on the screen.
One question.
Yeah.
Jim. So, one of the differences between a trustee instead of an executor is that you still have to inventory your estate, but the trustee can be trusted to do all that, and it's not as scrutinized, as deeply scrutinized from something like the court.
Yeah.
Because they just have to answer to the beneficiaries, correct?
Right, now, this is, the question was about how formal do you really need to be as the trustee as opposed to the executor because of the court wanting all that stuff. If you're the trustee, yeah, you still need to keep records,
Yeah.
but you have to be as formal in dotting the i's and crossing the t's as you need to for the beneficiaries
Yeah.
to be happy, which can be a lot less formal. Do you really need to cross-reference the 4 cents in interest coming into the trust from the interest on the account if the beneficiaries are fine if you just have, here's all the bank statements in the period we were administering the trust, which should also be a lot shorter than what's going through probate too. Any other questions before we move on? I'm at slide 25, so we're getting close. Okay. All right, so cross-reference all of the expenses on with the estate account statements. Again, all this has to line up. The distributions to the beneficiaries. You don't necessarily want them to all have to wait for everything until the very end of probate to distribute all of it. Usually at some point in the process, you can distribute a big chunk of it. I wouldn't advise doing it at least until you end up getting the notice to creditors in the newspaper has run its course.
Right.
And then after that, it's like, okay, we know there are no other big debts coming in. But at the same time, I'd caution them not to distribute so much that we can't pay the accountant for the tax returns and make sure that there's no taxes that are going to be due. But again, you should be involving the accountant all the way along here. So, and then whenever the beneficiaries are getting their final amount of money, this is when you need to make sure they are coming and picking up and signing off that, yes, I received this money. If you send them the check and the form, I got my money. Suddenly it's like, yeah, I'm too busy to sign this one form and send it back, even though you sent a self-addressed stamped envelope.
Right.
And now you're hounding them for paperwork, and there's no money left in the estate to pay you for hounding them for the paperwork. So either get them to sign the form first and then go ahead and send it out, or have them come by your office and pick it up if they're local. All right, so now the final phase, that's the accounting, and this is where you do have to show the court, here's all this stuff that we've been analyzing and getting proof for and putting it all together, and you're sending it into the court, and it all has to balance down to zero. You also have to get that proof that the notice to creditors ran. I don't know if they do it differently in your state. The actual newspaper has an affidavit that they send to us that yes, it ran, and here's when it ran, and they put a clipping right there. And again, funeral homes have to have a zero balance. I had a client, and they passed on, and now we're doing the estate, working with the son. The funeral was in New York, because that's where the family was. For whatever reason, 3 requests, and then finally, do I have to hire local counsel to sue you? Because what they kept doing is sending the funeral bill, which showed the balance at the bottom, and a stamp, paid in full. No, the court needs to see that zero at the bottom. And for whatever reason they wouldn't understand that. Again, this is how stringent probate can be on these little formalities that can hold everything up, which is why I tend to hate doing that type of work. All right, integration with trust settlement. Okay, look, you gather the information on the assets, you pay the bills, you keep the records like we talked about, and then you distribute the assets to the beneficiaries. So how does this work in conjunction? If there are expenses in probate, every expense needs to be justified. You need the invoice, you need the canceled check, you need to show the bank statements. But look, if there's a lot of money that's in the trust, and the trust does say it's going to take care of your bills, why not pay it from the trust? And avoid that extra paperwork that has to happen if you're going to do it through the probate court process. It's just less that you have to justify to a court and hold things up if you can pay the expenses. Now, something that if there's actually a creditor claim that comes in, I'd probably pay that out of the probate account if the money's there for that, just to show the probate court. But other than that, why not pay whatever bills there are out of the trust? Pay the attorney and other professionals out of the trust if that's acceptable. And I talked about the vehicle thing. I knew I had it somewhere in here. Buy the vehicle out of probate if it's in probate, if somebody in the family wants it, for exactly what Kelley Blue Book tells you it's worth. All right, so just the overall plan: limit probate using the revocable living trust that is funded, and focus on trust funding. Limit the probate transactions as much as possible. Keep all of your paperwork organized, and only work with the executor or administrator, but at the same time, you're balancing that against making the beneficiaries feel included. We actually have it in all of our estate planning engagement agreements that we will only work with the person that you told us you wanted who's still alive and competent, in that order. So if you've got oldest son, oldest daughter, younger son third, younger son starts calling up and asking questions and start trying to tell us what to do something. No, you need to talk to your older brother. He's the one who's in charge. They can bring in whomever they want. And I recommend, at least for a couple of calls, that they're included in that, or a couple of meetings they're included in that. They're gonna get bored and then let you actually get to work. But at least they have that feeling of being included. And now you've got this. It should be big enough in your notes that you can actually scan that and download those materials. And I will keep them up through the end of the day on Tuesday. This is just all those North Carolina forms that I was referencing that's in there, but it does have that estate administration workbook and a couple of other things in there that I've used over the years. So if you're looking at doing probate as part of your practice, good for you. I don't want to, but this is something that will hopefully help you explain all of this stuff to your clients. So we're half an hour ahead of schedule. Ask whatever questions you want, give whatever stories you have. Maybe I'll come up with some more, but let's go ahead and open everything up. Yes?
When you talk about using Kelly Blue Book value, is that the private party value versus trade-in or private party?
Private party value versus trade-in, yes. There was a third option, right? I just typically use retail. I typically use the private party
It's
value.
wholesale value.
Okay. I typically use private party value just to be consistent, and the clerks are usually fine with it.
Yes, Maryland requires private party value.
Okay.
It won't take it. Something I've heard attorneys say in Maryland, that, oh, it's after 6 months, I can't get it. It's not true. If you use the Kelly Blue Book, you can contact them. They actually have an archive department. For $50, they can give you the value of that car that person died 3 or 4 years ago. So that, many people who read the process don't even think about starting the process.
Right.
I had one, the man didn't go in the house for 6 years after his aunt died. And then he wouldn't go. He gave me the key. Went in there and found it was still a reporter.
Yeah.
Found this bag full of papers. We brought the papers home. I don't have time to go through these papers. I was involved with another family probate that's on the day right here. It was a mess in Florida, but one of the best attorneys here is Leslie Long. She's quiet now, but she handled it down there. I'll give her a shout out now. She's going to hear from her later. She's outstanding. But long story short, my first untrusted was my wife to go for the bag. David, did you know his aunt had $600,000 in a voided account? 6 years. Sadly. Guess what? It was now 1.1 million.
Okay.
I threw that in as an example of the things that come from in probate.
Yeah.
And all the extra family members, like, where's mine? We're gonna pull you up, sure, $4.50 an hour, and you're your phone call. I do that all the time, I don't bother.
Okay.
Point being, you never know what you're gonna find.
Yes.
Question about bequests.
Mm-hmm.
So in the workbook, there's a place where they can write out the bequest and they can sign off on all that. And number one, so if you have a car that's bequested, okay, then somebody else speaks to that. You know, how do you handle that typically? How should a trustee handle that so that it's not contentious? Like, because Dad told me I could have it, but it's not written there. And Mom said after Dad died, and so all those kind of stuff. And so who arbitrates that?
So let's make sure I'm setting this up correctly for the question. It's listed in the trust. This car goes to this person, but they never retitled the car over to the trust. I'd say at the very least it's an ethical obligation to make sure that's the beneficiary that gets it. And I think they would legally have a cause of action if you sold the car out of probate to someone else. Now, as a practical matter, if you can work this out with that beneficiary, where they're going to get the exact amount on Kelley Blue Book distributed from the trust to them in lieu of getting the car, and they get to buy the car for exactly that amount, well, then the money goes back into the trust, and again, it's one retitling, and you followed exactly what the trust said. They are getting the vehicle. It's just we didn't retitle it twice in order to get it there. Does that answer it?
Sure.
Okay. What other questions or stories do we have? Yes?
This is more just of a comment. If you're trying to convince people why they need to do a revocable trust. In California, it can take 3 to 6 months just to get the letters testamentary. And if there's a house with a mortgage,
Yep.
that has to continue to be paid
by
by the
somebody.
family until the executor has access to the accounts.
Mm-hmm.
So,
Oh, yeah.
Good
and that
point.
can be long, that's all county dependent. Some counties you can get the hearing date as quick as 2 months. Some are 8 to 10 months out for the first initial hearing
Yeah.
to get it done.
Yeah, the point is there may be bills, and in some places probate may take a couple of months just to get the letters to get stuff, and hey, those mortgage payments are still gonna be due.
Now,
Good
most
point.
mortgage companies will work with you if you can show them there's a probate been filed and you're waiting. They will forego the foreclosure procedure. They just want to make sure it's not just not being paid. But it's
Yeah.
more work to go through.
Yeah. Yes?
So what is everybody using for best practices for these bills? I mean, to have an account available, how is it titled? Do we do like 3 months bills set aside so we've got an emergency fund because we're all perfect planners? You know, but who has access to that after death?
Well,
What's everybody using for best practice here?
you're talking about if they've got the revocable trust.
They have a revocable trust. So now
Okay.
you've got the successor trustee having access to the account, is that what you're saying?
Yeah, they can step right in.
Right, what if it is a probate? They haven't listened to our advice.
They haven't listened to our advice.
Somebody gonna pay out of pocket.
Yeah, they're probably gonna pay out of pocket until the money and the funds are available.
And we have another story in relation to what you're speaking about in California. The trust was in the name of the house was in the name of the trust, only son with the mortgage. And we told him, the trust accounts were there, paid the mortgage. He didn't do it. He almost lost it. Because he would not listen. He was 38, 40-year-old man. And then he comes back to us and the mortgage company wouldn't give him any information until he presented what he needed. We told him what to do. He would not do it. And that house went on public auction. And that's when he finally called us. And we said, we've been trying to tell you for 6 months.
Yeah.
And he almost lost it for no reason.
Yeah.
Another cautionary tale, we had a client, husband and wife, set up the trust. He died. It's about 2 years later. She decides she's gonna go with that nice young man who was a real estate attorney, and he said she doesn't need a trust. So he canceled the trust and did a will for her. He never moved the primary residence out of the trust. And now she's dead. And it's a huge mess that this trust that was officially canceled
Wasn't defunded.
didn't defund it. Yeah. So, yeah.
Did you clarify for me there, you got a trust, you got, say, $30,000 vehicle, and the person passes away, it's not funded to the trust. Then personal property, is that personal property?
Well, it's a titled vehicle. I think your state would have classification, is it personal property or whatnot, but look, it's a titled vehicle. It's not like a blender or a couch. It's got title paperwork that needs to be fixed and worked with.
Check
Yeah.
to see if your state has, Virginia does. We could put a beneficiary on the title of a vehicle in the state of Virginia. And I think now there's 30-some states that allow it. That's another way, because Virginia likes to charge, because it's in the name of the trust, and mine are, oh, you're now a business, and we're not gonna give you your exemptions. That was a nightmare, finally got that squared away.
Yeah.
But it may be, that you can bypass the whole thing by putting a beneficiary on the car and wash your hands of all of it.
Tennessee didn't have that, did it?
They're saying through DMV.
Yes, through DMV,
Yeah.
beneficiary
Yeah, a
on
lot
the
of
vehicle.
states have it now.
You can only have one beneficiary on the vehicle. They have no obligation, just like any other beneficiary. They don't even know about it until you call them up and hand them the keys and the title. But that's another way to do it.
Yet North Carolina started doing that, thankfully. I mean, it was
Yeah.
such a nightmare
It
for
is a
my
nightmare in
clients.
Virginia.
Couples can now own it joint with the right of survivorship, and I believe now, if it's an individual, they can put a beneficiary.
Now, and I'm sure, I don't know about Carolina, but in Virginia, if you have a lien against it, you don't own a title until the lien is clear. The vehicle has to be paid for before you can put a beneficiary on it. Because you don't have the physical title in your hand to take to DMV to retitle. But for $15, you solve the problem.
Yeah. Well, $15 and that visit to the DMV.
Well, still, you can do that. We've gotten a lot better about that.
Yeah.
But yeah, that's one way to handle it.
Yes.
So we were talking earlier about the probate levels for different states, and Tennessee's 50,000, but now, as of July 1st last year, it is less than 50,000. You can't fill out that $100 and some form yourself. You have to go to an attorney and have them file it for you.
And
Okay.
it's not the small state affidavit anymore, it's a limited probate.
Oh, okay.
Yeah, just learned that.
All right. So the Tennessee attorney lobby for probate is pretty good then, right? I'm sure they had something to do with that.
They could almost stack in the deck.
I have a question on the public death notification. I don't know about you guys, we don't have a local paper anymore that anybody gets because it's too damn expensive. And, you know, there's an online subscription, so at least your only option may be to do something online and just substantiate that you've done it if you have to. And it's not gonna go anywhere because nobody's ever gonna see it, more than likely.
Well, yeah, and this is the thing that I've noticed. We still have the News and Observer in Raleigh. They're a lot more expensive than the Wake Weekly, which it's Wake County. That's all online. And so it's less expensive. They just do it as a standardized fee. But always check to make sure that the court accepts that for the published notice to creditors.
Right.
Yeah, I was just gonna say, most counties, if you call the court, you can say, who's your list of, especially in the rural areas?
Yeah.
Who publishes for this town?
Right.
Because I've had clients who published and find out later, don't mean anything, you published it in the wrong paper.
Right.
And
Give
of
me a
course,
proper notice.
they were happy to take the money, right?
Exactly.
Yeah.
All right. Any other questions or stories?
Well, I don't know about you all, but obituaries in our neck of the woods, you don't see published obituaries anymore for the same fact. You've got to troll the local funeral home sites, and we do it to see if maybe we've heard about something or somebody's passed, because the papers are just, you know, a 2-line obituary is $500, and nobody's doing it. So that information, which is good and bad, isn't out there.
Well, yeah, the funeral homes have kind of taken over.
And it's
that
just
on their
published on
websites.
their site.
Yeah. All right. Any other questions or stories? All right. Any comments, Bobby? Anything else we need to cover?
Not that I know of. Go a longer break if you want.
Cool.
Let's go ahead and do a longer break.
Yeah.
Good job, Jim.
All right. Thank you.
Thanks, Jim.